force against someone else's will is against the law of man.
Well, I couldn't have put it better myself, me old China. For a minute there, I thought I was being forced into an obligation and I'm obliged to become a tenant. But enough of that. Let's look at the questions that Mark asked you over on our YouTube channel, and you still haven't given the answers to them. Question 1. Please provide evidence to support your belief of my or anyone else's agreement to be tenant for life. Question 2. Please provide evidence to support your belief of my or anyone else's agreement to the status of citizen. Question 3. Please provide evidence to support your belief of a legal estate created at birth. Question 4. Please provide evidence to support your belief you did not create land, so by impossibility it is not yours nor anyone else's to grant to any other or for you to use.
Well, thanks, Peacekeepers, for putting together that short video, and thank you for the challenge. I definitely accept, and I hopefully am able to discuss it in a succinct manner to give you more depth and clarity of the question that you are asking, or what Mark was asking. Now, we both agree that we find of the utmost importance to locate the truth about our connection to law and equity. We wish to locate the originating obligation, however that must look. Where did you find that older video, by the way, anyways? But nonetheless, it still holds absolutely true today, and those words are still absolute true. So from that point, we can then jump off and then discuss for the reasons hereafter I point out regarding what is law and what is equity. Okay? Now, as for your questions, I am pretty sure I answered them. Maybe not well enough, or it is not yet understood because of the depth of knowledge that you guys both possess, and which the majority also possess concerning what is law, including your rival, Black Belt Barrister, who is right according to how the system sees it, but nonetheless will never be discussed and debated through how you guys see it, because neither of these parties have ever discussed the law. In fact, a lawyer cannot discuss the law because this title of lawyer, powers and duties, are limited to equity only, not law. And as it relates to you, Mark, you and Mark, Brian, you are engaging in a status as a tenant called a citizen when you enter a lower court of equity and then wanting the judge to make a determination. So obviously recognizing a hierarchy of authority whereby this judge has to recognize you as a citizen, thereby execute those rules that govern this status. And then in the next breath, asking them, where does the government get its power to think it has a right to rule over the people? Through the legislation that the court then interprets, as there is no identified contract or trust that binds you as a citizen to an obligation. The devil is in the details for ears of formal discernment. Just going to let you percolate that for a few seconds within the old melon, to then next create another scenario, or possibly two. What if somebody came along and usurped your home? What action would you file, one in law or one under government legislation in equity? So as to force this usurper out of your home through proof of your contract, through your title deed, namely. What court is obligated to hear this matter? Or what if you or Mark are traveling abroad and get mixed up in some trouble that is not binding on you because the issue being raised is one that is not legislated as a rule within your own jurisdiction as a citizen, and so the issue is not noticed in your country? Would you not then seek protection from your accusers through your embassy, giving them the authority to represent you? Is this not proof of an obligation for the embassy to act without needing proof of an originating contract that makes your citizenship valid? We are all acting like children at the dinner table who are trying to negotiate our way out of eating the Brussels sprouts and still wanting dessert. whereby we know where the power comes from that enforces the decision, those who created the dinner. So essentially, do you see how you give up given the power through implication, and then in the next breath are asking where the power comes from? To paint a picture, I'm going to use some humor in order to assist in coming to terms of what is law and what is equity, to which you again, Brian, are only ever speaking to matters of equity. So obviously not law, that has you and Marc continue with your quest to finding the originating agreement that binds you. Are you truly interested in the answer you seek? If it flies in opposition to your quest, or perhaps this is just a data mining plot to which, to me, it matters not what your reasons are, because I really don't care, as it will end precisely at the level of truth each of us are willing to accept. Currently, what you have been doing is running a fool's errand. This is not an opinion of mine, but fact according to what is law and equity. This is exactly what you and Marc are essentially doing. You are broadcasting into the public, as an analogy, in order to gain solidarity about your notice of a stench in the air, asking if others also smell it too. They say they do, and confirm it smells a lot like ass. It smells like a fart. And after receiving a majority vote, although no signed contract exists, and so continue to run along through oral agreements to then pursue this matter, you and Marc next establish the criteria that is needed to investigate where the smell originates from. And your new formed fiction, which is the peacekeepers, want proof that it came from a unicorn's ass. And so, with this, you want the unicorn to be proven. I and the black belt barrister come along, one not willing to participate, and I, a willing one, whereby the black belt barrister, BBB, explains exactly where the stench is coming from, the foundation, the same courts you use to effect an obligation upon yourselves as citizens, and then I come along with a cornerstone to end this debate, a matter of absolute truth, and say, there is no such thing as unicorns. This is where we are at currently. All your actions are identifying the rights you both are in agreement with, engaging the BBB, who has no interest in law, only equity, and he's confined within a predetermined duty and power subject to statutes, and I, who is only speaking to the law, for it is the law that can only secure the dominion rights inherent in each individual, who is not first belonging to a group and so a fiction, and you guys who represent the group, a fiction called peacekeepers that are searching for the unicorn who's responsible for the stench. So I'm not really surprised at all that you thought I did not answer Marc's questions. Because firstly, you must stop looking for the unicorn and stop pushing the Brussels sprouts around your plates. Because they are there, nonetheless. First thing I will point out is this absolute truth. There will never be, or will there ever exist, a signed contract between the people of nature having a full right of dominion and the government, as it is impossible. Government is a group, is a fiction of law. It does not or has ever effected rules over any action pertaining to nature. In fact, it has never created patents over that which exists in nature. People of nature that you are trying to stand upon, to then in the next breath agree to overreach, is not the same type of people who remain as acting citizens. People have a right to the law. Citizens have a right in equity. Period. People of nature have to first come in through a legal personage in order to intercourse with government, so subject to a defined duty and power so that the rules of law can next govern. While absolutely the position of a citizen is annexed to the capacity of a tenant for life. If you are a citizen, you have to be a tenant upon a land right. No exceptions, for that is the law and of right to equity. Law does not govern people first, and so government cannot force people into its servitude because it has never been granted the power to do so. What has been granted is through contract, with the monarchy only. Now, not the crown, but the chattel that sits upon the throne that represents those interests of their land rights belonging only to law, not equity. Government has legally entered a contractual right to use the legal estates of the people held in the monarchy, and so is forced to perform upon this agreement a defined duty to act as an accountant for the waste it creates and its citizens upon the land in order to secure profits annexed to the legal estate created at birth. There is no right existing in law and equity that first does not go through a land right first. A right is not a creature of nature, as nature exists independent of needing an agreement first to continue as is. English law, for absolute greater certainty, can only enforce an obligation against the type of land interest a person is either possessing or has a right to possess over a land interest, to which then establishes an obligation upon the law or equity to enforce the agreement over the identified estate matter being heard. Is it in law or is it in the right in equity? And they are of two completely different subject matters, namely one held through a life and the other through a perpetuity construct like a corporation soul or an aggregate called government or church. The Lord's temporal have a different land right than the Lord's spiritual, who then both are different than those held in the monarchy, and most certainly completely different than those held by a grant transfer to government, and lastly, those who hold an estate interest through the device of citizens or citizenship. The origins of all of this was discussed through William Blackstone, who was commissioned to define the foundations of English law, which includes natural law, but not the laws of nature, over the rights to holding a land interest in law or equity. To then scoff at the books evidencing the origins of all your agreements, the actual book that proves the obligation against the type of land interest you are currently in agreement with, through the careful edited words of William Blackstone, all witnessed through your very own daily actions, is why you will not ever comprehend, or any of your group or followers, the evidence of the obligation. You also bring in the Cestui Act of 1666 to prove a point with those who do not understand what law is, thereby making the point moot, and also discuss the 1688 Bill of Rights and the Act of Settlement of 1700 in the same manner, which is before the era of William Blackstone, yet discount Blackstone commentaries under the guise as antiquated and of no value. Why discuss matters of the 17th century at all then? I have done over 60 videos explaining this and countless of posts describing where the obligation originates, so I'm not going to then recreate it here in this video, since it is futile until you agree to stop only looking to the rules of equity and want to come to know, now learn first of what is law, to those who actually were responsible for describing it. Not quotes from people who have no clue as you have no clue as to the position they are coming through. The quote is discussing if you are in possession of an equitable interest and so has nothing directly to do with English common law. The point is none of those questions Marc is asking is going to be satisfied when he is not dealing with the right subject matter that evidences there is no agreement with the people for all the reasons I had already expressed. You are looking for the originating agreement in equity. You both are searching for unicorns. It doesn't exist in the manner you are both seeking. There is no connection with what you are trying to find in the matters of law and equity. And so, I will leave you two and the group peacekeepers with this. The people's rights to their full autonomy exist before any legal fiction, including the monarchy, for the logical and sound principles of reason. As Francis Bacon describes, and who also I'll provide a link to the actual law being discussed through his eyes of the time, namely a discourse concerning the Statute of Uses 1535 under the reign of King Henry VIII, that law is reason and equity is conscience. Reason is steadfast. There is no wiggle room. Whereas equity follows the law to then come in under a new agreement to use what is held in law and separated through a trust instrument that then exhumes notice of your obligation by this one very logical fact. Starting as an infant, you cannot be held to a contract or made to discern your rights as a beneficiary or choose alliances or allegiances or rights of citizenship. And so, all your originating interests have to be transferred over to trustees who ensure your legal estate is secured through law. This means this is done through an operation of law and not an act of parties, to then be held until you make your own intent known so as to affect the rights determined in law, which is through reason, not conscience. Whereby the rule of law has to, and here is the biggest hint to all of it, all of your queries, is you cannot ever be seen in English law, in the English law system, have any rights in law or equity if first the English law does not attach notice of your birth to be annexed to a land interest in law and equity through the device of birth. Birth of what? Is the original answer you should seek. And so after you pass into the rules that govern contract, so can suffer the test for lack of mutuality, thereby you are now of full age to make your intent known in law, which is the age of 21 in common law, then you can make your intent known through your own individual action, thereby obviously establishing the obligation for those of the duty and power to accord according to your notice intent, which also is finally doing, is removing the burden of taking care of your legal estate, the obligation you are currently creating through your own systemic agreements. Which brings up another identifying right you are also holding. You're coming in again through your very own actions via your current comprehension of equity, whereby you also have the right to come in as a beneficiary and create your own bills of exchange. But instead, you're using the Jews' banking system, which is known as making an agreement to a particular ethnic group. Now, listen to this. A group means it is not a life. Thereby, like the Roman Church and Parliament and government, cannot ever have a right to the common law legal estate held in your name, created at birth. If you are now lost, I would suggest to re-listen to what I had already described, as this is new information, and generally the brain's neural pathways are in most cases not wired to listen to what I'm telling you. Evident in your clamoring to use only equity without first knowing what is law. You both are not even using equity to its full potential, made obvious by your very own actions to locate this unicorn. There is no or will ever be a document between the people and government because the people cannot contract with government directly. And why? Through operation of law only instills a confidence in the monarchy to then, as a fiction of law, negotiate patents for the use of your legal estate with government. There are plenty of agreements between these two. I think there is even a coat of arms with a unicorn in it. There is your unicorn. It is in equity and has nothing to do directly with the people because it is notice of an act of parties, and so a fiction of law. I will end here. There's no sense speaking to this matter until you stop trying to prove the obligation through the reasoning that the proof is firmly established that you both are not only are agreeing to, but also discuss matters of an equitable interest, and will only bring this type of subject matter to court. But you have to stop searching for this elusive unicorn first. They don't exist, period, until you look to debate that they do. All is moving in confidence and so continuance, until you and your group stand upon the law in reason and learn to read Blackstone and so learn what is law. All your questions are answered in these set of books and also posted online for free so that you will finally determine where the obligation exists. It is you, only you as an individual. As for, is there proof? The law is the proof, to which this is not the issue being ignored currently, as I am, and a few others, are caught in procedure is the issue, to which it has to be simple, and even though I firmly believe I am there, my acquaintances believe in another approach. And also, by the way, I'll be writing properly negotiable instruments, so legal bills of exchange and equity, that set off debt for a few of my closest friends. Whilst I still continue to use the law only to settle my legal estate held jointly by trustees. In closing, the law proves Blackstone, high courts of common law, those of chancery, parliament, governments, etc., have absolute evidence, all exhume absolute evidence of the succession of land interests they have a right to govern over, and so create laws against these interests. Any of you, as a creature of nature, so of life, have free will to then make your intent known either through individual will or through a fiction, a group like the peacekeepers who can only deal with those interests in equity. I am still open to the 10% agreement I countered against your offer of proof of the elusive obligation. And so we'll end this firmly, that until either one of you drop the concept of equity and come to finally determine what law is, you will never come to realize the foundations of the legal estate, those equitable interests, whether you're acting as a settlor, a trustee, a quasi-trustee, you're acting as a statutory owner, a personal representative, but you're always acting in a corner of a tenant, because a tenant is the only foundational capacity that is used in all English law, whether you are a lord or you are, well, Marc is the only one that's not a tenant, but whether you're a lord or you're in the Lord's spiritual, or you are, within the group, or you are a citizen, or it doesn't matter, a settler or beneficiary, it doesn't matter. You have to be a tenant first, because that is all that English law can ever run rules over. They have no right to the soil. That's nature. They don't patent soil. They patent rights to the use of the soil, to which then creates obligations and secures certain duties and powers, so that they are prohibited and limited to only work within those duties and powers, so that when you are ready to finally vest your legal estate, which is the only thing that's created at birth, well, then a couple of things in equity, then we'll never be speaking on the same topic. And you will never understand BBB either. It is just the way it is, and why the courts, and every time you walk in there, and I'm sure it came right out of Marc's mouth himself, the judge, he didn't listen to us. Well, you know what? I'm telling you why. If you have any reference to the Peanuts characters and the teacher going wah, 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 that is exactly what the judge is hearing. Peace be with you guys. Thank you again for the challenge. And peace be with you, which is firmly established in law only.